Welcome to RIN's podcast, talks about confiscating assets in the EU. In this episode, we shall discuss protecting fundamental procedural rights in the procedure of mutual recognition of seizure and confiscation orders. The construction of the European judicial area is a process aimed at integrating different legal systems as harmoniously as possible, founded on the rule of law and recognizing as an inspirational principle the fundamental rights enshrined in the European Convention on Human Rights. The cornerstone of this space is the principle of mutual recognition, which implies the collaboration of different legal systems on the presumption that each has achieved high standards of respect for fundamental rights and procedural guarantees. Early instruments of judicial cooperation in criminal matters, such as the European arrest warrant, merely invoked the need to guarantee fundamental rights without specifically constructed clauses. With Regulation 1805, an important step forward was taken in ensuring effective mechanisms to safeguard mutual trust. Therefore, today, the violation of fundamental rights by the state adopting a decision to freeze or confiscate constitutes explicit grounds for rejecting mutual recognition. Respect for fundamental rights as a limit to judicial cooperation in criminal matters has been the result of a long process of maturation of the case law of the European Court of Justice. This ground for rejection also plays a significant role in defining the scope of application of the principle of mutual recognition, as it could be used to hinder the circulation within the European common legal space of Italian asset prevention measures. These measures, even according to judgments of the European Court of Human Rights, raise compatibility issues with some fundamental principles of criminal matters. It is by no means guaranteed that such measures will be reciprocally recognized by other member states, and there is no consensus on exporting this confiscation model to Europe. The issue of crime prevention prompts reflections as complex as they are necessary, including the proportionality control of the measure requested regarding criminal property. Indeed, these instruments have a significant burdensome nature and do not provide the typical guarantees of criminal proceedings, as they can be pronounced even in the absence of a prior criminal conviction. European criminal defense lawyers have long advocated for greater attention to defense rights in cross-jurisdictional criminal proceedings. It is essential to ensure access to defense counsel for the accused, even in the state where the requested measure must be executed, and not just in the state where the seizure or the confiscation measure was requested. Otherwise, the right of defense of the individual could be limited. By guaranteeing respect for high standards of protection, greater efficiency in criminal proceedings is also ensured, as judicial decisions will be more stable. Ensuring rights is always a win-win. Justice prevails. The road to building a European space of freedom, security, and justice is long, but it is important to remain optimistic. While concerns for ensuring a high level of efficiency guide European legislative decisions, the importance of concretely guaranteeing defense rights is increasingly evident and widespread in the European criminal policy debate. In the podcast episode, the discussion will be led by Caterina Scialla, PhD in criminal law and assistant researcher at the University of Campania Luigi Vanvitelli, along with Amedeo Barletta, criminal lawyer and vice chair of the ECBA, European Criminal Bar Association.